Good evening and welcome to Know Your Rights. I am Janelle Mencias and I will be your host for the next couple weeks until Khadijah Usher returns. On our show, you hear directly from attorneys who break down the law and explain the rights of citizens on common legal challenges that confront Belizeans on a daily basis. Tonight, we will be discussing the rights of landlords and tenants when it comes to property rental. You can watch us live on Channel 7 or on Facebook at Colorblind Multimedia Productions. You can also participate in the conversation by posting your comments or questions on our Facebook page or by emailing us at info@colorblind.bz. Joining us tonight to help us understand the many challenges around property rental is attorney Aldo Reyes, founding partner at Reyes and Retriege Law Firm. Good evening and welcome, Aldo.
Janelle, thank you. Thank you for having me.
So we're here to discuss the rental of property, and we've all been on some side of the spectrum. If we haven't been the tenant, we've been the landlord, or we've been both. So one of the things that I read about when I was reviewing the Landlord and Tenant Act is the first thing was about a contract or a lease. Now, do Belizean landlords typically have a habit of producing a lease when they're doing their rentals?
Well, first thing, Janelle, I must say you must have been very bored to have read the Landlord and Tenant Act. But from my experience, the norm has always been that no, landlords tend to not produce written contracts. I would say that's a rarity. I would say the vast number of leases in Belize tend to be oral leases, leases where a landlord and a tenant simply say, yes, I'm going to lease this property and this is the rent and you pay me monthly. So the answer is no, that's not the norm. So
in terms of that contract, why should landlords be encouraged to produce a contract when they're doing rentals? How does it protect them and how does it protect the tenant?
Yes, well, I would say not only just for landlord and tenant arrangements, but for any agreement, it's always advisable to put it in black and white. And it's done for the protection of both parties so that they can be clear as to exactly what it is, each of their obligations is. If there's a dispute, then one of them could always turn to the contract and say, here it is, Mr. Landlord, you're responsible for repairing my toilet or repairing my wall. For certainty, it's always best to have it there. If there is no lease, if there's nothing in writing, not even emails, then that is always ripe ground for a dispute to arise.
Now, is the contract at the discretion of the landlord, or is there a standard when it comes to certain things?
Well, if there is a contract, it's the norm for the landlord to produce one. But if a landlord doesn't produce one, that does not preclude a tenant from saying, you know what, here is a lease, would you be minded to sign it? I mean, a tenant could take the initiative and produce it as well. And truth is, a lease doesn't have to be necessarily in a particular format. It can be handwritten. It's always good, at the very least, to have something like that would be advisable. So either party could produce a lease.
In the case where there's not a lease and the tenant wants to put in a new fixture, I know of a case where I've had a friend who wanted to get the bathroom fixed, yes, and the landlord didn't do it.
Yes.
Does she have the right then to make it habitable for herself?
Well, let me start first. Where premises are being leased as a dwelling home, a landlord is under an obligation to ensure that it's reasonably fit for human habitation. That's the first thing. However, in the absence of any agreement to the contrary, a landlord is not under an obligation to make the premises any better than it was when it was first leased. Now, if a tenant wants to change fixtures, a tenant ought to seek the consent of the landlord, because even if there is no written lease, the law implies certain obligations on the part of both landlords and tenants. And I believe it's in the Registered Land Act, there is an implied term that a tenant ought not sublet or alter, well, there's one for subletting, but ought not alter the premises without the consent of the landlord. So if you want to take out a fixture or replace a fixture, essentially alter the structure of the premises, then really you should seek your landlord's consent. And
I'm guessing in the case where the landlord does not, adhere to the request, then it's best just to find somewhere else.
Yes, exactly. No, that's not to say that, say like a faucet, for example, a faucet or a shower head, a pipe is in need of this repair, then really the tenant is under an obligation to repair small things like that. But if there's if the tenant wants to do major changes, alterations to the structure, then in those instances, the landlord's consent is needed.
Now, you spoke about obligations on both the side of the tenant and the landlord. What are generally the obligations of the tenant?
No, I assume you're speaking when there is not a written lease.
Right, when there's not a written lease.
All right, like I said, where there is no written lease, the law implies certain obligations on both landlord and tenant. Now, the obligations on the landlord are, for example, a landlord, once he's let premises, he's to give that tenant, it's called peaceful use and enjoyment of the premises. And what that essentially means, if I let you my premises, I'm not to do anything that takes away from that lease. So, for example, I can't erect a structure in front of your door. I shouldn't make, if I own neighboring land, I shouldn't make so much noise for it to cause a nuisance to you.
Okay.
So that is an example of a term that's implied in the lease on part of a landlord. Another implied lease is if I lease, say, a portion of my building, then I as landlord would be responsible for maintaining the roof, the walls, the common drainage, any common areas. Okay. So those are examples of obligations on the part of the landlord. Now, on the part of the tenant, there's an obligation that they will pay rent. There's an obligation that they will not do anything in those premises that would cause a nuisance to neighboring occupiers. There is an implied obligation to repair the interior. However, a landlord is under an obligation to do major repairs, like I said, like of the roof, of the walls, of the structure. And there's also, and this is another implied obligation on the part of tenants, and it's something that you just mentioned, that they ought not make alterations to the premises without the consent of the landlord. One other question that comes up commonly is whether or not a tenant can sublease. And actually, again, there's an implied term that a tenant ought not sublease the premises without the consent of the landlord. And the law says, but the landlord should not unreasonably withhold their consent.
Okay.
So those are examples of implied obligations, even when there is
cutting your yard.
Yes, exactly. Yes,
that.
Things like that. There's an implied obligation of repair and maintenance as well.
Okay. Now, another thing that usually comes up is vacating the premises. How much time must the landlord give to a tenant? What's a reasonable amount of time? Okay.
The question isn't necessarily what is a reasonable amount of time. You have to look at the nature. And again, I'm assuming there is no contract in this scenario where there's no written lease. When there's no written lease, the amount of time notice that must be given to vacate depends on the type of lease. And it depends on the period of the lease. So if you're leasing premises on a monthly basis, so say you pay your rent monthly, the first of every month for that month. If it's a monthly lease, then the landlord or the tenant must give the other party at least 1 month's notice. Okay. So if it doesn't matter if you've been occupying that premises for 10 years, if you're occupying it under an oral periodic monthly lease, then the landlord need only give you 1 month's notice. Okay. And at the end of that month's notice, then the tenancy is deemed as terminated and really you should come out. Now that applies to, like I said, to both the landlord and the tenant.
Okay.
So a tenant can also say, you know what, I want to get out. I've lived here for 10 years, but that tenant only needs to give the landlord 1 month's full notice, a full month. And then at the end, they can vacate. So it depends on the period. So for example, again, say you're occupying under a weekly tenancy, you pay by week, then the landlord or tenant need only give 1 week's notice.
Okay. Well, we'll take a short break, and when we return, we'll get a little bit deeper into the conversation. Welcome back. So we're discussing tonight the rental of property, and I'm here with attorney Aldo Reyes, and he's telling us about some of the issues that Belizeans have generally when it comes to rentals. Now, earlier we spoke about the leasing, and now I want to get a little bit more into stuff like non-payment. How does a landlord, deal with non-payment for their rentals?
Okay. Well, first of all, rent is perhaps the most fundamental obligation of tenants in a lease. If a tenant is not paying rent, essentially they're breaching the lease. And if a lease is breached, then the landlord can start taking steps to terminate that lease and eventually have the tenant vacate the premises. However, landlords ought to bear in mind that just because a tenant has not paid rent does not mean that they can automatically re-enter and terminate the lease immediately. The law implies steps that have to be taken by a landlord in the event that a tenant is not paying rent. And the law specifies that if a tenant is breaching the lease, and that includes paying rent, that they ought to serve a notice on the tenant specifying the breach. So the landlord has to serve a notice on the tenant saying, listen, Mr. Tenant, you have not paid rent for January, February. I need you to pay within a reasonable time. The law says actually a reasonable time. And if they don't pay within a reasonable time, then the landlord can actually terminate that lease and seek to get the tenants out. So a notice has to be sent, an actual written notice has to be sent.
And this is with or without written?
With or without,
okay.
Yes.
And then now, does that give the landlord the opportunity to say change the locks? Can you put out your tenant's property?
No. Now this is one misconception, and it's a step that landlords take quite frequently. The truth is, it's actually illegal for a landlord to do that. Now, although the landlord may have taken steps and may have terminated the lease, if a tenant refuses to come out, that does not entitle the landlord to simply go in and forcibly remove that tenant. The landlord has to proceed in the courts, they ought to proceed in the courts to remove that tenant. Now, as to which court they go depends on the amount of rent that the tenant is paying.
Okay.
If a tenant is paying, I believe it's $1,200 a month or less, then they have to go to the magistrate's court. If it's above that, then they go to the Supreme Court. But to answer your question, a landlord should not simply remove a tenant's items, and they should not just remove the locks. If they want to seek the eviction of a tenant, they should really go to the courts to get an eviction order.
What is that court process like? How long does it take generally to go through that?
You're asking a very loaded question. It's, like I said, matters in the magistrate's court tend to proceed a lot quicker than matters in the Supreme Court. I would say that if you lodge a claim in the magistrate's court, it should take you a few months. In the Supreme Court, at the very least, it will take you, I would say, about 6 months, especially given the workload of the Supreme Court.
And do we find generally that the landlords are getting back what is owed to them? Does it work that way?
Truth is, I would say, in my experience, no. Because when these tenants are not paying rent, I would venture to think it's not because they willfully don't want to pay rent. The truth is, a lot of the times they don't have the rent to pay. And once the landlord has taken them to court and secured their eviction, these tenants tend to just disappear. They can't find them. So although the landlord may have gotten possession of their property, a lot of the times they're unable to seek to recover the back rent that was not paid. And that is very common.
And has there ever been a case where it leads to imprisonment of?
No, I find that to be very rare, yes.
Okay.
Imprisonment is normally a recourse of the very, very last resort by the courts.
Okay. Now, can my landlord just go into my house to inspect it to see the condition of it, or is there a process to doing that?
Okay. We were speaking about these implied terms earlier. The law implies that a landlord should be granted access to the property just to inspect it. However, that doesn't mean a landlord can just show up in the middle of the night or even show up during the day to say, I want to see my premises. The law says that the landlord ought to give notice, reasonable notice, and that he ought to be allowed to inspect the premises at a convenient time. So the landlord must give notice to say, next week I would like to come and have a look at the property maybe at midday. And really the tenant should give them access to inspect.
And that's under the supervision of the tenant
yes,
as
of
well?
course, yes.
Now, one of the other things that you always hear about in rentals is the security deposit.
Yes.
What's this security deposit really for? In some cases, the tenant doesn't get it back.
Yes.
Should they get it back?
Well, the security deposit is exactly as the name describes what it is. It's really a deposit that's paid down to secure the performance of a tenant's obligations under the lease. And of course, it's normally paid at the very beginning of the lease. And yes, if a tenant has complied with all their obligations under the lease, if they've kept the place in a reasonable state of repair, if they've paid all their rent, at the end of that tenancy, they should get back that security deposit. But what I would recommend to all tenants, prospective tenants, is that when you move into the property, I recommend that you take photos of it. Right. That way, if the landlord at the end of the lease is saying, you know what, that little crack in the wall was not there, I'm going to take your deposit for it. You have photos to say, no, that it was there. So it's the landlord can only or ought only keep that security deposit if the tenant has breached some obligation in the lease or has not paid their rent. Then they can keep that security deposit. And it's not the entire security deposit. So it's only the amount that is necessary to cure the breach of the tenant.
Now, there's also the issue of non-payment of bills that the landlord may inherit from the tenant. How does that work? Does the landlord have the obligation to take care of those, or is there some kind of recourse that they can take?
A tenant is really responsible for their utility bills while they're occupying the premises. Okay. And again, another common occurrence where tenants leave the premises and they leave outstanding water bills or outstanding electricity bills. The tenant is responsible for those bills. Of course, the landlord has the option of suing the tenant to recover those sums and even recover their legal costs if they end up having to go to court. But if the landlord can find the tenant, then it's fortunate of them.
Now, going back to earlier in our discussion, we also spoke about subletting rooms. Yes. Does a tenant have the authority to do that? If the agreement was for just maybe one person staying there, having more than one person in the space, or renting another part of the building, how does that work, and what can the landlord do?
If you don't have an agreement that if a tenant doesn't have an agreement that allows them to sublet, then as I had mentioned earlier, the law actually places a restriction on a tenant from subletting. So the simple answer is no. But as I had mentioned, the law says the tenant cannot sublet without the consent of the landlord. However, the landlord ought not unreasonably withhold that consent. So if if a tenant can say, listen, I just want to sublet a room to a student.
Right.
I've received a security deposit. They're going to be bound by the same obligations as I am. Then I would venture to say that it would be unreasonable for a landlord to withhold consent in an instance like that.
Okay. We will take a short break, and when we return, Aldo will be answering some of your questions that you sent in. Welcome back. We continue our conversation on the rental of properties with attorney Aldo Reyes. One of the questions that we wanted to ask as well is, does a tenant have the right to use a security deposit as the last month's rent?
No, no. There's no such right. Bear in mind, as I had mentioned earlier, that the security deposit is really a security to secure the performance of a tenant's obligations under the lease. It is very common, though, for landlords and tenants to agree that, all right, take that security deposit as the last month's rent. But that, I would say, is actually at the risk of a landlord because, well, first of all, no, a tenant does not have the right to say, take that as the last month's rent.
Right.
That security deposit is supposed to be there for the entire duration of the lease. Now, if it so happens that at the end of the lease, the tenant moves out and the landlord goes in and realizes that there's need for significant repair,
right,
then they would have lost their security deposit. They would have no money to use to effect the repair.
But it's not a replacement for...
No, it's not a replacement. It's not, yes. So the answer is no. The tenant does not have a right to say, use my security deposit as my last month's rent.
And then the other thing I wanted to ask you about is, when it comes to the court process, what if I go through all of that and I still don't get that problem remedied, the person's still living in my house? What do I do next? Okay.
Once you've gone to court, I'm assuming you're going to court to secure the eviction of a tenant.
Right.
Normally what accompanies that is a claim for what's called mean rents. So for the entire duration that the tenant remains in the property, that tenant remains liable for rent during that time. Now, assuming a landlord has secured an eviction order as well as an order for back rent, and the tenant still refuses to come out, it's at that point that a landlord can apply for an ejection order. Essentially, it's the bailiff. They go in and they forcibly remove that person from the premises. So that is one option. It typically doesn't happen, but it's a remedy that's available to a landlord. Now, if the landlord, now they've secured the eviction of the tenant, but they haven't secured the back rent. Another remedy that's available is called distress, where the landlord, again, can go with a bailiff. They have to apply for it. They go with a bailiff to secure all the personal assets of the tenant. And then those assets can be put up to auction to recover whatever is due to the landlord.
And there are certain assets that are exempt.
There are certain assets, yes. You've obviously been reading the Landlord and Tenant Act, as you said. But yes, certain things like tools of the trade, bedding, the person's clothing, things like that are exempt. You can't distrain on things like that.
All right, now we'll go to some questions from Facebook. We have from Angelica. She explained that they have been renting for 4 years, never missed a payment, and now the landlord is only giving them 1 month's notice to move because he sold the house. And he is also threatening to take them to court if they don't leave. Is 1 month's notice enough from a legal standpoint? What are her options if she cannot find another place in 1 month?
Yeah. I think we had touched on this a bit earlier, where it depends on the type of lease. It depends on the period. And again, I'm assuming that Angelica does not have a written lease. So it depends on the period by which she pays rent. So, and in all likeliness, she does pay rent monthly. Right. Assuming it's a monthly lease, then yes, the landlord need only give her 1 full month's notice, and then she would have to leave. If, however, she refuses to leave, the proper recourse that the landlord should take is going to the court to seek an eviction.
Which is what?
Yes, exactly. And Angelica remains liable for the period during which she remains in the premises.
Right. Now we have a question from Stacy. Stacy wants to know what can be done about the lopsided contracts where tenants have to give 3 months notice and the landlord only has to give 3 days notice. Can you explain the purpose and the use of the security deposit because landlords take advantage? I think we already discussed this earlier as well.
That question seems to have two sides. Well, first of all, where a landlord offers a lopsided contract, I would always encourage tenants to try to negotiate it. That's obviously a very lopsided agreement. But the landlord should not, ought not put in provision like that he only needs to give 3 months notice. Really, he should give the full period's notice by which the rent is being paid. But regardless, just for certainty, I would always dissuade a tenant from accepting a contract like that. Don't feel because the landlord has submitted a document that you have to sign it. You should, I would highly encourage to enter negotiations and try to work it out. You know, tell the landlord, listen, this is unfair. How come I have to give you 3 months notice, but you only need give me three days?
Like
That's
you
ridiculous.
said, typically it will be the timeliness of the payment. So if I'm paying monthly.
Yes, correct. Yeah, so it's monthly, then I need at least a full month's notice.
Right.
And again, well, we had already touched on the security deposit question.
Our final question is from Dora. Dora is renting the upstairs of a house and another family is renting downstairs. The person collecting the rent on behalf of the landlord told her that she nor her young son have any right to play in the yard, nor can they have a dog. Does Dora have the right to use the yard or bring a dog to the rental?
Well, I would say, first of all, this person that's collecting the rent, I would only consider them a collecting agent. They're not the landlord, so they don't have a right to make any such stipulation. If at the beginning of the lease, Dora has been using the yard and has had a dog, then that is a term of the lease, that she does have a right to use the yard, she does have a right to bring a dog. There's no implied restriction in the law that you cannot have pets. So I would say that collecting agent, that collection agent does have a right to say, no, you can't use the yard, or you cannot bring in a dog.
Like you also said earlier, that the landlord is to ensure the peace of the tenant.
Exactly, yes, correct. And if that was allowed at the commencement of the lease, then that is a term of the lease, and they ought to allow the tenant to peaceably enjoy the premises that's being let. And
do you have any final words of advice that you'd like to give to our audience?
Yes. Again, as I had mentioned at the very, very beginning of the show, please put your lease in writing. You can do something as simple as writing it down on a piece of paper and you and the landlord sign it. That is perhaps one of the most fundamental things that I would encourage landlords and tenants to do. Tenants, if you feel like you're being taken advantage of by a landlord, I would encourage you to seek consultation. There's a legal advice, try to contact an attorney if you feel you cannot afford an attorney. I believe there's a legal advice and services center on Albert Street, at the end of Albert Street. Landlords are not allowed to simply go in and remove your items from the premises. They are not allowed to simply go and change locks. So a lot of times tenants are taken advantage of simply because they don't know their rights, which is what we're here for, trying to guide you along your rights.
Well, we've come to the end of our show tonight. Thank you, Aldo, for joining us and providing us with much information on tonight's topic. Know Your Rights will be back next Monday with attorney Deshaun Arzu-Torres, who will explain how to access the courts to get justice. If someone missed it, tonight's episode will be available for viewing on Facebook and YouTube. Thank you for watching, and good night.